2024 revisions to Florida condo law regarding condo board meetings. Section 9. Paragraph C, D, F, G, and Q of subsection 2 of Section 718.112 Florida statutes are amended, and paragraph R is added to that subsection to read 718.112 bylaws. 2 required provisions. The bylaws shall provide for the following and, if they do not do so, shall be deemed to include the following. See Board of Administration meetings. In a residential condominium association of more than 10 units, the Board of Administration shall meet at least once each quarter, at least 4 times each year. The meeting agenda must include an opportunity for members to ask questions of the board. Meetings of the Board of Administration at which a quorum of the members is present are open to all unit owners. Members of the Board of Administration may use email as a means of communication, but may not cast a vote on an association matter via email. A unit owner may tape record or videotape the meetings. The right to attend such meetings includes the right to speak at such meetings with reference to all designated agenda items and the right to ask questions relating to reports on the status of construction or repair projects, the status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. The division shall adopt reasonable rules governing the tape recording and videotaping of the meeting. The association may adopt written reasonable rules governing the frequency, duration, and manner of unit owner statements. 1. Adequate notice of all board meetings, which must specifically identify all agenda items, must be posted conspicuously on the condominium property at least 48 continuous hours before the meeting except in an emergency. If 20% of the voting interest petitioned the board to address an item of business, the board, within 60 days after receipt of the petition, shall place the item on the agenda at its next regular board meeting or at a special meeting called for that purpose. An item not included on the notice may be taken up on an emergency basis by a vote of at least a majority plus one of the board members. Such emergency action must be noticed and ratified at the next regular board meeting. Written notice of a meeting at which a non-emergency special assessment or an amendment to rules regarding unit use will be considered must be mailed, delivered, or electronically transmitted to the unit owners and posted conspicuously on the condominium property at least 14 days before the meeting. Evidence of compliance with this 14-day notice requirement must be made by an affidavit executed by the person providing the notice and filed with the official records of the association. 2. Upon notice to the unit owners, the board shall, by duly adopted rule, designate a specific location on the condominium property at which all notices of board meetings must be posted. If there is no condominium property at which notices can be posted, notices shall be mailed, delivered, or electronically transmitted to each unit owner at least 14 days before the meeting, in lieu of or in addition to the physical posting of the notice on the condominium property. The association may, by reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed-circuit cable television system serving the condominium association. However, if broadcast notice is used in lieu of a notice physically posted on condominium property, the notice and agenda must be broadcast at least 4 times every broadcast hour of each day that a posted notice is otherwise required under this section. If broadcast notice is provided, the notice and agenda must be broadcast in a manner and for a sufficient continuous length of time so as to allow an average reader to observe the notice and read and comprehend the entire content of the notice and the agenda. In addition to any of the authorized means of providing notice of a meeting of the board, the association may, by rule, adopt a procedure for conspicuously posting the meeting notice and the agenda on a website serving the condominium association for at least the minimum period of time for which a notice of a meeting is also required to be physically posted on the condominium property. Any rule adopted shall, in addition to other matters, include a requirement that the association send an electronic notice in the same manner as a notice for a meeting of the members, which must include a hyperlink to the website at which where the notice is posted. To unit owners whose email addresses are included in the association's official records. 3. Notice of any meeting in which regular or special assessments against unit owners are to be considered must specifically state that assessments will be considered and provide the estimated cost and description of the purposes for such assessments. If an agenda item relates to the approval of a contract for goods or services, a copy of the contract must be provided with. the notice and be made available for inspection and copying upon a written request from a unit owner or made available on the association's website or through an application that can be downloaded on a mobile device. 4. Meetings of a committee to take final action on behalf of the board or make recommendations to the board regarding the association budget are subject to this paragraph. Meetings of a committee that does not take final action on behalf of the board or make recommendations to the board regarding the association budget are subject to this section, unless those or meetings are exempted from this section by the bylaws of the association. 5. Notwithstanding any other law, the requirement that board meetings and committee meetings be open to the unit owners does not apply to a. Meetings between the board or a committee and the association's attorney with respect to proposed or pending litigation, if the meeting is held for the purpose of seeking or rendering legal advice, or b. Board meetings held for the purpose of discussing personnel matters. D. Unit owner meetings. 1. An annual meeting of the unit owners must be held at the location provided in the association bylaws, and if the bylaws are silent as to the location, the meeting must be held within 45 miles of the condominium property. However, such distance requirement does not apply to an association governing a timeshare condominium. 2. Unless the bylaws provide otherwise, a vacancy on the board caused by the expiration of a director's term must be filled by electing a new board member, and the election must be by secret ballot. An election is not required if the number of vacancies equals or exceeds the number of candidates. For purposes of this paragraph, the term candidate means an eligible person who has timely submitted the written notice as described in subparagraph 4a of his or her intention to become a candidate, except in a timeshare or non-residential condominium, or if the staggered term of a board member does not expire until a later annual meeting, or if all members' terms would otherwise expire, but there are no candidates. The terms of all board members expire at the annual meeting, and such members may stand for re-election unless prohibited by the bylaws. Board members may serve terms longer than 1 year if permitted by the bylaws or articles of incorporation. A board member may not serve more than 8 consecutive years, unless approved by an affirmative vote of unit owners representing 2/3 of all votes cast in the election, or unless there are not enough eligible candidates to fill the vacancies on the board at the time of the vacancy. Only board service that occurs on or after July 1st, 2018 may be used when calculating a board member's term limit. If the number of board members whose terms expire at the annual meeting equals or exceeds the number of candidates, the candidates become members of the board effective upon the adjournment of the annual meeting, unless the bylaws provide otherwise. Any remaining vacancies shall be filled by the affirmative vote of the majority of the directors making up the newly constituted board, even if the directors constitute less than a quorum or there is only one director. In a residential condominium association of more than 10 units or in a residential condominium association that does not include timeshare units or timeshare interest, co-owners of a unit may not serve as members of the board of directors at the same time unless they own more than 1 unit or unless there are not enough eligible candidates to fill the vacancies on the board at the time of the vacancy. A unit owner in a residential condominium desiring to be a candidate for board membership must comply with subparagraph 4a and must be eligible to be a candidate to serve on the board of directors at the time of the deadline for submitting a notice of intent to run in order to have his or her name listed as a proper candidate on the ballot or to serve on the board. A person who has been suspended or removed by this division under this chapter, or who is delinquent in the payment of any assessment due to the association, is not eligible to be a candidate for board membership and may not be listed on the ballot. For purposes of this paragraph, a person is delinquent if a payment is not made by the due date, as specifically identified in the Declaration of Condominium, bylaws, or Articles of Incorporation. If a due date is not specifically identified in the Declaration of condominium, bylaws, or articles of incorporation. The due date is the first day of the assessment period. A person who has been convicted of any felony in this state or in a United States district or territorial court, or who has been convicted of any offense in another jurisdiction which would be considered a felony if committed in this state, is not eligible for board membership unless such felon's civil rights have been restored for at least 5 years as of the date such person seeks election to the board. The validity of an action by the board is not affected if it is later determined that a board member is ineligible for board membership due to having been convicted of a felony. This subparagraph does not limit the term of a member of the board of a non-residential or timeshare condominium. 3. The bylaws must provide the method of calling meetings of unit owners, including annual meetings. Written notice of an annual meeting must include an agenda, be mailed, hand-delivered, or electronically transmitted to each unit owner at least 14 days before the annual meeting, and be posted in a conspicuous place on the condominium property or association property at least 14 continuous days before the annual meeting. Written notice of a meeting other than an annual meeting must include an agenda, be mailed, hand-delivered, or electronically transmitted to each unit owner, and be posted in a conspicuous place on the condominium property or association property within the time frame specified in the bylaws. If the bylaws do not specify a time frame for written notice of a meeting other than an annual meeting, notice must be provided at least 14 continuous days before the meeting. Upon notice to the unit owners, the board shall, by duly adopted rule, designate a specific location on the condominium property or association property at which all notices of unit owner meetings must be posted. This requirement does not apply if there is no condominium property for posting notices, in lieu of or in addition to the physical posting of meeting notices. The association may, by reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed-circuit cable television system serving the condominium association. However, if broadcast notice is used in lieu of a notice posted physically on the condominium property, the notice and agenda must be broadcast at least 4 times every broadcast hour of each day that a posted notice is otherwise required under this section. If broadcast notice is provided, the notice and agenda must be broadcast in a manner and for a sufficient continuous length of time so as to allow an average reader to observe the notice and read and comprehend the entire content of the notice and the agenda, in addition to any of the authorized means of providing notice of a meeting of the board. The association may, by rule, adopt a procedure for conspicuously posting the meeting notice and the agenda on a website serving the condominium association for at least the minimum period of time for which a notice of a meeting is also required to be physically posted on the condominium property. Any rule adopted shall, in addition to other matters, include a requirement that the association send an electronic notice in the same manner as a notice for a meeting of the members, which must include a hyperlink to the website at which where the notice is posted, to unit owners whose email addresses are included in the association's official records, unless a unit owner waives in writing the right to receive notice of the annual meeting. Such notice must be hand-delivered, mailed, or electronically transmitted to each unit owner. Notice for meetings and notice for all other purposes must be mailed to each unit owner at the address last furnished to the association by the unit owner, or hand-delivered to each unit owner. However, if a unit is owned by more than one person, the association must provide notice to the address that the developer identifies for that purpose, and thereafter, as one or more of the owners of the unit advise the association in writing, or if no address is given or the owners of the unit do not agree to the address provided on the deed of record, an officer of the association, or the manager or other person providing notice of the association meeting must provide an affidavit or United States Postal Service certificate of mailing to be included in the official records of the association affirming that the notice was mailed or hand-delivered in accordance with this provision. 4. The members of the board of a residential condominium shall be elected by written ballot or voting machine. Proxies may not be used in electing the board in general elections or elections to fill vacancies caused by recall, resignation, or otherwise, unless otherwise provided in this chapter. This is an excerpt of the 2024 revisions of the Florida Condo Law that was adopted by the state legislature in March, signed by Florida Governor Ron DeSantis in June, and took effect in July 2024. This video and audio was created by Miami consultant Peter Zaleski of condovultures.com by copying and pasting the verbiage directly from the Florida legislature website. The audio is an AI-generated voice. To obtain a digital written copy of the changes to the Florida Condo Law used for this video and/or audio, please visit https://laws.flrules.org/2024/244. To watch and/or listen to a narration of all of the 2024 changes to the Florida Condo Law, please visit http://www.condovultures.com.